All right. Good morning, good morning, good morning. And it is Friday, December 15th. And of course, we have our basic preliminary discussion points. First off, as always, though our forums are private, these sessions are public. And so anything that is said will be recorded and put out on public forums. So be aware of that. Join our forums, join our 3 forums. We now have our Tressa forum in full force and effect as well, in addition to the landlord tenant in the main forum. And the Tressa forum is really going very well. Those of you who are agents who haven't been part of it, I suggest you join. David Ursino is pulling a Herculean task answering all the questions, and everyone is incredibly grateful for his efforts in that regard. And as a final note, and I know Elaine, you're going to mention it as well, but I'm going to mention it too because we're all trying to push. Guys, we are now $3,000 away, or even less than $3,000 away from our final goal of $25,000 for breast cancer research for this year. Every year we try to make a difference. Last year was for a Native women's shelter. This year it is for breast cancer. It means a lot to all of us. Everyone that we know, everyone knows people who have been affected by breast cancer. This is the way you can give back to those people who actively try to make your professional lives easier every day, and at the same time help yourself, help your loved ones, help your family. I would ask everyone to please make a $50 donation if you have not done so already. And if you have done so already, make another $50 donation. Why not? Let's get that number up. All right. So without further ado, Elaine, Denise need no introduction. They run the forum. So I'm not even going to make an introduction because everyone knows you guys. Let's take it away. Let's listen to your wisdom, guys.
Thank you, Mark. Denise, can you come so I can see you? Because otherwise I'm talking to a blank. There you are. Hey. So I want to just give a shout out to Mark for all of the hard work he does, and he certainly takes a great amount of time trying to inform you and organizing these sessions and everything else he does. And I want to also give a particular shout out to Sandra Jackson, who honestly, we could not manage these Facebook pages without her. One of the reasons with which we're trying to do the fundraisers this year for breast cancer in particular is because Sandra is a recent breast cancer survivor. And in honor of her, I'm going to ask everybody to make sure that we get to that $25,000 mark, just to say thank you to Sandra and how much we love and appreciate her. So there you go. That was my rah-rah. So we thought, Denise and I were thinking that we would just kind of do a year-end review. Harry is online. He's not well. He's going to text me stuff if he wants to participate, and I'm happy to always have Harry participate. So here's what we're going to talk about. We're going to unpack what's happening at the Landlord and Tenant Board, and both Denise and I just attended a stakeholders meeting the other day, so we're pretty up to date on it. We're going to talk about some timelines. We're going to talk about some new case law that's come out that will have impact for you. We would like to discuss corporate landlords and corporate tenants and 12s and L2s. And Denise, you and I didn't talk about this, but we should include some info about bad faith applications. We're going to talk about cash for keys, Airbnb, winter maintenance, and stick around for agent liability, because this is the one that you all should be aware of, because there are now cases coming up against brokerages and agents for some bad acting. So that's the landscape. We will try to answer some questions. As always, we will never answer questions that are case specific. And we may limit how many questions we're able to take. So I'm going to jump in. And Denise, what's happening at the board? And thank you for being here. Before I do that, Denise Ranger is owner of Ranger Paralegal Services. Prior to being in the paralegal world, Denise was a licensed real estate agent. So she brings a kind of unique perspective to the site, and the information that she provides is with greater knowledge than some of us have around your responsibilities as agents. And before I forget, and Denise I'll come back to you, I wanted to also just give a shout out to Brett Lockwood, who is no longer on this site, but Brett was a regular participant on the site. And the reason that he's not is because he's now an adjudicator. So bravo to Brett. I've been in front of him a couple times and he's been fabulous. And we're delighted that he's moved into that role. All right, so back to stop blabbing, Elaine, and talk to Denise. Denise, let's talk about the stakeholders meeting that we both attended. What are some of your takeaways? I can't hear you, Denise. You're on mute. Your computer's on mute.
Can you hear me now?
I can hear you now.
Okay, good. Okay, so with regards to the stakeholders meeting, a lot of the information that we received was sort of technical with regards to how how the board is moving forward and how they plan on dealing with the backlog. But for the purposes of you guys, the realtors out there, you need to understand what the timelines are for basic evictions. If you are acting in the way of like a property management, providing property management services to some of your clients as well, we have a timeline of about 4 to 5 months for matters involving non-payment where the landlord is seeking arrears. Actually, I'm going to share my screen. I'm going to make sure that this is up. Can you see my screen at this time?
No.
Okay. So
Yes.
I'm just going to share my screen. Okay, good. I'm just going to skip over to board timelines. So with regards to N12 applications, which I'm sure is the big thing that you guys are interested in, is eviction for taking back the unit, whether it's for the landlord's personal use or for purchaser's own use, which is a big thing. And we're going to be talking a little bit more about that as we get into the presentation. Right now, we're seeing about 8 to 12 months for the scheduling of an application to be heard for purchaser or landlord's own use. That's just scheduling. Now, it's quite often that you're going to get to the board and we're still having issues where there may be more matters scheduled for a particular block than can be heard. And if the matter is complex, then there's a really good chance that that matter may be adjourned because it's not complete or it was never even started that day. So to be truthful, I would not enter into an agreement of purchase and sale where vacant possession is a requirement because your parties are going to be shocked at the delay. So keep that in mind when you're drafting your clauses. And again, we'll get to that a little bit more. Tenant applications are still taking a really, really, really long time to get through the process. The board has recently implemented kind of like a case management hearing where tenant matters specifically, where they are having these early kind of case conferences to figure out whether or not the application is viable, what the real issues are, trying to narrow things down I think in an effect or in a attempt to whittle down the backlog and remove excess unnecessary applications and potentially to limit the adjournments as well. So they're trying to manage the flow getting to the hearings as well. And then the board is committed to ending the backlog or getting through the backlog by the end of 2024. And the way that they're going to do that is by just bombarding and really getting through and scheduling a lot of cases and hearings. They've hired a lot of additional adjudicators. They're still hiring adjudicators, but right now they're experiencing a caseload that's similar to the high water mark that they had back in 2009. And for those of you who've been around in the real estate world for a while, you will remember the mortgage meltdown at that time. And they're seeing similar caseloads right now of about 7,000 to 8,000 new cases being filed each month.
Exactly. So and they were, one of the things that was a bit surprising for me was they're actually expecting that to increase to 9,000 new cases a month. So, I mean, think about it from the perspective of what a mess residential tenancy is in Ontario, particularly if you're seeing 9,000 new cases a month. It's pretty astounding. So Denise, we were talking about some of the new case law that's come out, and I know that there were some pieces that you wanted to share, so I'm going to ask you to do that now.
Sure.
Okay, go for
Okay,
it.
so I'm just going to change my slides. This case, Elkins v. Van Wissen, is going to be a very, very important case for realtors moving forward because it involves the requirements for the test for bad faith in a situation where it's for purchaser's own use. And it's so in this case in particular, the vendors were selling their tenanted property. The realtor disclosed the realtor for the purchasers disclosed that that there was an interest in the property involving a future development of that property. When the purchasers and the vendors entered into the agreement of purchase and sale, there were only two individual purchasers. But prior to the completion of the transaction, those two purchasers created a corporation, became directors of that corporation, and notified the solicitor for the purchasers notified the solicitor for the vendor to tell the vendor to express that the title of the property was going to be taken by a corporation. When the corporation was finally formed, they added two additional directors, and then they served an N9, or sorry, an N12, so that the tenants would vacate the unit for personal purchaser's own use. Well, we all know that a purchaser cannot, or a corporation cannot take a property for its own personal use. So this was a very interesting case because it went to divisional court. Divisional court said that the board got it right, that the case was dismissed. They had a very narrow look at the good faith obligation on the part of the landlord in serving that N12. They determined that the test was too narrow, and that at the time that the N12 notice was served, the vendors had no reason to believe that the purchasers would not take possession and reside at the property for residential purposes. So the Court of Appeal decided that the board decision was too narrow of a focus in that. Divisional court upheld it, and Court of Appeal said again, no, it's too narrow. Specifically, they went back and looked at another case that came out of the board at a board level decision called Duarte, and in that case, they said that the Duarte decision got it right, and specifically, they looked at the way that it was considered, or that section was considered. And what happened in Duarte is, I'm just going to read the paragraph, is that in relaying the purchaser's intention to terminate the tenancy, the landlord does not serve as a mere messenger with no duties or obligations to the tenants. By conveying the purchaser's stated intention to occupy the rental unit, the landlord initiates events that had the serious consequence of ending the tenancy and compelling the tenants to relocate their family. And as a result, I find, this being the board member, find that the landlord has a duty to the tenants to exercise some due diligence to confirm the good faith intentions of the purchaser before putting the eviction in motion. So
what does that mean? So Denise, because we have a habit of talking in legalese. Yep. So just in a couple of sentences, what does that mean? What's the impact?
So the impact here is that your sellers of tenanted properties have an obligation to determine whether, or to do some due diligence to determine whether that purchaser who says they need it for their own personal use is saying that in good faith. They're bringing a good faith intentions to this transaction rather than putting the seller in a straw man position and trying to sidestep the RTA. If it looks like you're going to sidestep the RTA, then you're probably trying to sidestep the RTA. And the board has the power to determine and ask questions to determine whether or not that's what actually happened. So if you've got purchasers who are, say it's a corporation, and before title is conveyed, they're going to dissolve the corporation or bring in a single person as a partner, and that individual is going to try and take possession as for their own personal use. The board's going to see that. They're going to ask questions. They've been given the tools. They have been told that they have teeth in the act to enforce these issues and these decisions. And so they've been told by the Court of Appeal to actually do that. So
Right.
when you're representing these buyers and sellers involving a tenanted property, you have to make sure that as the realtor to make sure that your butts are covered. Make sure that they know what they're getting into and what the ramifications are if they are trying to do an end run around the RTA, because eventually somebody is going to be used as a scapegoat, or as an example. Sorry, not a scapegoat, but as an example. And I foresee personally, I foresee some maybe some hefty fines and some hefty orders coming down.
Yeah, and in that regard, I mean, I keep getting these cases where a corporate entity is trying to do an N12 for their own use. They go to the board, they fail, then they transfer shares of the corporation to an individual. And now the individual is trying to their rights as a landlord. And each and every time that happens, it fails. So,
Yep.
Part of the message that we want to give you is that you may think that you're more clever than the board, but the reality is that most of us who've been working in this field for a long time, and including the adjudicators, can see through what it is you're trying to do, and the board actually has an obligation to look at the true substance of a transaction. So really what we're trying to do is encourage you not to try sidestep the board and to follow board rules or RTA rules all the time, because you are doing a huge disservice to your clients that if you don't. So that kind of leads into this whole N12 L2 applications that we wanted to talk to you about today. So we're finding that, we're getting a lot of these. There's, it's particularly critical these days. We've got, I don't know how many landlords, and I'm sure Denise has the same issue. They're calling crying because they can't afford their mortgages on their own properties that they reside in, and they can't afford the mortgages on their residential property, and the rent increases that are allowable under the act don't match the interest rate hike. So now we're being put into a deficit position. And I've had more than one landlord crying and saying that they're going to have to file for bankruptcy. So it's leading to some bad behaviors with respect to landlords who are quite desperate. And now we get into a scenario where the property's up for sale and we've got issues related to vacant possession. And this is an ongoing issue because of the board delays. And I mean, reality is that nobody's going to want to buy a property that has a tenant in it unless they're looking for an investment property. If they're looking to reside there personally, most people cannot wait 8 to 12 months to take possession. And that's, if we go through the normal course, that's what it's going to take. So one of the ways with which you deal with that is to ensure that you have the proper clauses in your purchase and sale agreements to protect either your seller or your buyer. we bump into, Denise and I bump into a bit of an issue with this because we are of the view that as licensees of the Law Society, we are allowed to provide a very specific scope of legal services, and drafting these clauses is not within that scope. So we stay cautious about that. However, and since Harry's here, he can throw it into the chat. Harry's retired, so he doesn't have to worry about these things the same way that Denise and I do. And Harry has an amazing forms package that every brokerage should actually avail themselves to. It's got all sorts of clauses in there for lease agreements, what should be in there. You can just pull down, like there's a menu and you can just click, copy and paste what you need. It also has some language in there around what should be on the purchaser and sale agreements. If I remember correctly, Harry, just shake
You
your.
do, yep.
Yeah. So, and Harry, how much is the package?
The forms package is $99.95. It contains 30 different forms, but the lease appendix is the centerpiece of it. I might add that decision that Denise was talking about, it also dealt with the issue of not only did the seller, he couldn't be a straw man, but it's not just good faith at the moment the notice is handed to the tenant. The good faith requirement lasts all the way through. So, for example, you serve the notice because you think the purchaser's moving in, but somehow the purchase evaporates and you no longer have a purchaser. An unscrupulous landlord could have said, well, last week when I gave the tenant the N12, in good faith, I believed the landlord was moving in, and that's been pretty common. But the decision was pretty clear that you can't do that. In that case, there would be an obligation to go to the tenant and say, hey, have you rented a new place yet? Because my deal has fallen apart. Don't go rent a place, because the obligation of good faith by the seller / landlord continues. And of all the things a seller can do to make sure he's not a straw man or she's not a straw woman, is never, ever even think about working with the buyer in terms of an N12 and vacant possession, etc., unless the buyer or the person in the buyer's family who intends to occupy is willing to swear an affidavit stating their good faith intention to do so. After all, if you file an L2 application at the board, that same person will have to file that same affidavit. But by making them do it as part of the offer process, it puts their ass on the line, so to speak. And those that run away and say, there's no way I'm going to provide that, what you know, sellers, is that the buyer probably has no intention of moving in. Thanks, Elaine.
Yeah, thanks, Harry. And just to your point, I have a case that just recently I had to deal with, which was exactly that. The property sold, the tenant waited and waited and waited. There was 2 extensions done on the sale, and by the time the hearing came to be, the deal was aborted, and my clients wanted me to proceed, and I'm like, there's absolutely no way I'm going to proceed on this, because it would require me to lie to the board, which I'm not prepared to do, and if we tell the truth, the board's going to dismiss. And ultimately, we made a cash for keys deal on that. But you know, there is this expectation that the seller wants to proceed on an aborted deal, and like that's just absolutely not something we can encourage. In fact, we should be discouraging it. So thank you, Harry. And so again, with these N12s, you've got to be really, really careful. And what I would suggest to do, because what we're finding is we're getting panicked sellers who are coming to us and saying, well, my agent told me that we could close in 2 months. What's happening here? Why can't we close? And then, of course, when the deal gets aborted, there potentially is some liability on the seller side, and they're looking at their agents to say, why did you tell me something that was not true? So agents, what I'm going to suggest to you is that you put in writing with your clients that you've advised them that there's an 8 to 10 month delay at the Landlord and Tenant Board. And you do that and put it in your back pocket so that if they, if the deal aborts and there's litigation that follows, can't come back on you to say, why didn't you tell us? You're always straddling that line of providing legal services, which you're not actually allowed to do, and being a good advocate agent. So that's our little tip. Denise, just very briefly, was there any, because I'm looking at the time, is there any other thing that you wanted to say about N12s or L2s?
With regards to N12s and timeline and all of that, getting back to that case and what Harry said, just to emphasize that, it's not just an obligation on the seller when they hand over that N12. And if something happens catastrophic where the deal is going to fall apart, I would even go so far as to say that if you've got any additional any changes to that deal other than a waiver of a condition. So say, for example, the buyer wants to come back and change the closing date, or they want to add in add in another purchaser. I would put it to you as realtors that you should be having a discussion if you're representing the seller of a tenanted property to ask why. Why is this necessary, and get it in writing from the other side as to why they want to do something, because that could have an implication to the good faith of the purchaser wanting to take the property for their own use. And if you don't do that, it may come back and again bite you in the butt, because you're there to protect your clients and you're looking out for their best interest. This is one of those things if you're dealing with tenanted properties.
All right, thank you, Denise. I think I'd like to move on to cash for keys because there's so many questions on the site. And what is the right ask and how do you do cash for keys? So I can tell you how, I've probably done about 90 of them in the last year, and that's because I have some big projects I'm working on. In each case, I do a specific agreement to the particular nuance of the unit that we're dealing with. So a lot of people have asked us for templates on this. We're not prepared to give them to you because, as I say, they're nuanced. And as well, quite frankly, this is how we make our living. So you're asking us for our work for free. I do not recommend that agents do the cash for keys agreements themselves. I recommend that they go to a licensee and ask them to do it because there's certain clauses that should go in there. There's certain language that needs to be in there. And as I said, it's unique. There's also a mechanism with which payouts should happen. So I will tell you this piece. So let's say I'm doing a $30,000 cash for keys deal, which is not unheard of. In fact, most of mine are in that ballpark. I don't give the tenants all the money up front. I give them a portion of it right away on signing, and the remaining balance I do when they hand in the keys on the date that they say they're going to hand in the keys. Why do I do this? Because a lot of tenants are not able to come up with first and last moving expenses themselves, and this 15, let's call it $15,000, really helps alleviate that, and it's far more appetizing for a tenant to know they've got money and they can afford the move, other than being totally stressed out. The numbers themselves, why am I looking at 30,000? They're all over the place. I get asks, and I'm sure Denise would agree. She gets the similar asks as I do, but I get asked for $100,000. I've been asked for $1 million. That's obviously just somebody being cheeky. But when you're talking about this with your clients, you got to kind of do a reality check, because tenants are smart. And there's all sorts of Facebook groups out there for tenants who give advice on how to get more money and how to delay processes. And yes, the reason I'm speaking in this way is because primarily I only represent landlords at this stage. But The way that we get to our figures is the reality. We've got a unit, let's call it $1,500 unit, which I know is cheap, but the tenant's been there for 10 years. The equivalent unit is going to be $3,000 for them to move. Plus they've got their moving expenses. So they're going to be spending on a yearly basis, double their rent. So on a yearly basis, under that scenario, they're going to be spending $18,000 extra. And going forward, that will continue. So, you know, you're really covering them off for about a year and a bit, a year and a half of the added expense plus some of the moving expenses. And that's how we get to those numbers. Now, obviously, if you can negotiate something cheaper, good on you. But the going rates are anywhere between 10 and I'm going to say 40 is depends on the unit, the location and, you know, what the actual rent is. But that's sort of what we're looking at. But again, I just need to reiterate to you is please don't draft those yourselves, because if they're not drafted correctly, you know, you're handing over a pile of money to a tenant with virtually nothing to back you up and no recourse if the tenant doesn't actually leave. With respect to that, I would also say, just a reminder to you, if we have to do some form of eviction, whether it's on a cash for keys or an N12L2 application, the final piece of the puzzle on an eviction is that the sheriff attends and removes the tenant. Now, it doesn't happen that often in these situations, but the sheriff in Toronto is taking a month before they'll come out. In Brampton, I believe it's 2 months. York region, I think it's about 6 weeks. So when you're thinking about termination dates, you need to accommodate for the fact that a sheriff may be required, and you have to start calculating that in your decisions around what proper termination dates should look like. So that's just a heads up. So because I'm just going to move on because I'm mindful of the time. Because of the situation at the Landlord and Tenant Board, because people are so fed up with being a landlord, and what's happened is that the pool is shrinking. I don't have the stats, but exponentially, the pool is shrinking substantially. Actually, Denise, can you just take down the PowerPoint for a minute so I can, because it's all I can see and it's distracting me. Oh, I lost Denise. There you go. Thank you. So what people have decided to do is look at short-term rentals, and particularly Airbnbs or Verbos. So let's distinguish between a few things. So we have Airbnbs, and there's a case that came out. It's a lengthy case. It dealt with a woman. It was all over the news, actually. It dealt with a woman who rented out a unit for 321 days, I think it was, through the Airbnb portal. And it had an end date. So it wasn't a separate short-term rental agreement. It was through Airbnb. At a certain point, the landlords got ill, or the owners, I should call them owners because that's the proper reference for them. They needed their home back, and or a family member got ill, I think, and they needed their home back, and the individual residing there refused to leave. So they removed that. They changed the lock, and that person was now locked out. So she brought the matter before the board, seeking to determine whether or not the act applied, and ultimately the act did not apply, and that the owner of the property was within their rights to do what they did. And it was a significant case. But that's because, so don't get any, the takeaway I want you to have from this is that this was done through the Airbnb portal, and as opposed to what some of you are doing, which is creating these short-term lease agreements. in the short-term lease agreements that I have seen that some of you have created, where you're clearly trying to work outside of the act so that you're not bound by the RTA, most of those agreements, in my view, would fail because it has a clear intention to skirt around the act. So I would be super careful about getting into that. The litigation that can arise from that is substantial. It could cost your clients a lot of money to navigate through the court system, because that's the kind of thing that will actually get into divisional court. And you're talking about $20,000, $30,000 in legal fees. So I'm not recommending that you do that. So similarly, I wanted to mention about the student housing. So I'm getting a lot of calls about student housing these days. And so this comes back to what, I'm kind of jumping all over the place, but corporate tenants versus, not. And the recommendation is that you do not take, or you be very careful about taking corporate tenants. So I just want to relay that to student housing. So I've recently had a couple of cases where a student housing provider has, and I can tell you the name, it's Irby Enterprises, and they deal with a particular racialized group. And these are students that come from, I'm not sure whether they're from China or I can't remember where they're from, but they're from a particular country. They advertise in their local country. These are U of T students. So Irby would rent out from a landlord, usually a condo, and then, let's call it $3,000 a month for a 1-bedroom condo near U of T. And then they'll subdivide that 1 bedroom into 3 bedrooms by putting curtains or partitions up, and then rent it out for $4,500 a month, so which is illegal. So this is the model that a lot of these places are using, and so you need to be super careful when dealing with them because it's breaking all sorts of rules. Similarly, we have scenarios. Oh, I just lost my train of thought. Sorry. Okay. I'll remember it probably tonight when I'm thinking about it later. But anyway, yeah. So this notion of corporate tenants really lends itself to people renting it out under a corporate entity and then re-renting it for profit. And what the approach will often be, it's for my employees. So I own a corporation, and I want to house my employees. If you're dealing with a company like, I don't know, Metrolinx, where there's big projects and they're coming into Toronto to work on a big project. Okay, that's reasonable. But if it's like 1, 2, 3, 4, 5 Ontario, your hackle should go up. There's something amiss. You're potentially setting yourself up for a real problem. And Denise, do you want to talk for a minute just about what that looks like from a litigation perspective, dealing with corporate tenants?
Absolutely. So in my experience dealing with corporate tenants or anything that is outside of a very straightforward, uncomplicated matter, you're looking at increased costs for litigation. So when you're dealing with a corporation, you're going to be dealing with whether or not the act applies. You're going to be dealing with somebody who may have deep pockets. They also have an obligation to make sure that the corporation is solid. So when you're up against that kind of an entity as your opposing party in a landlord tenant board situation, you should anticipate that if something goes wrong, your client is going to be facing adjournment. They're going to be facing additional preliminary matters. They're going to be facing additional types of applications. So the costs for that type of litigation is exorbitant. I would say that if somebody came to me in my office with that sort of a situation, I would say that by the end of it, just even a ballpark shoot from the hip, you're going to probably have about a $5,000 in legal fees, not including disbursements, not including, prepping, serving documents to whoever you may have to get process servers for that kind of thing. And if they're difficult to find, that's going to add to it. If the corporation acts has directors in countries that are not local, it gets even more expensive. So you need to do, again, it comes back down to due diligence. As you are an agent representing a client, you have an obligation to do what is in their best interest. So you have to do a little work getting into the due diligence part, or at least advising your clients to go get some legal independent legal advice about what this kind of situation could turn into, so they know what to look for, what to spot, what are the red flags, and have a discussion with your clients about um, their ability ability to deal with risk. Like, are they okay with high risk tenants? Are they looking for something that's really stable? You have to have that kind of conversation as well to be realistic with your clients.
Right. And the other piece that really becomes problematic is you don't actually know who's living in your unit. You know, you can have revolving people coming in and out of that unit. Some may be absolutely fantastic and wonderful, and others not so much. And I think especially if you're dealing with private landlords, you want to know who's in the unit. That's why we look to tenant screening as a mechanism before we say yes. And on that note, I want to move the conversation to this wonderful website that's been up and running. It's not complete, but it's called openroom.ca. So what that is, it's a listing. So private landlords are uploading orders that they've received from the Landlord and Tenant Board, and you can then go ahead and search. Now, there's another website called Canly, which I'll talk about in a minute. So Open Room is not by any stretch of the imagination a complete listing of all landlord and tenant boards, but people, as they learn about it, more and more people are uploading. And what you might find on openroom.ca is that when you're screening for a tenant, that this particular tenant has already been evicted 3 times for non-payment of rent. I have one tenant who's on a property on Dalhousie. He's gone through 3 different condos in that building. And in each case, he was over 35,000 in arrears. So those orders have now been uploaded onto Open Room. So hopefully the next time he's looking for a unit, the prospective landlord will look on there and say, oh my God, there's no way I'm going to rent to this guy because he's already 90K in the hole with 3 other people. So I recommend using that. There is Canly, which is the court case law site. It is not up to date. At the stakeholder meeting the other day, they were talking about working steadfastly to get it up to date, but frankly, there's so many orders that arise out of the Landlord and Tenant Board. It's really a full-time job to be uploading to Canly. So I don't expect it to be up to date for at least another 6 months. So openroom.ca is certainly the way to go. And on that note, I want to just slide over to some helpful tips that Denise and I talked about with respect to tenant screening. So I think I'm just going to give one, and then Denise can offer one from her side. First and foremost,
Elaine, I don't mean to, well, I'm sorry to jump in here, but if we could just take a moment, I can share my screen and show these the good people here that what Open Room looks like,
yeah,
what
that would be
Canly
great.
looks like really quickly. So I've got it queued up here. So just give me one sec. All right. So this is Open Room. Okay.
No, it's not. No, it's not.
Oh, hold on. There we go.
No. Yeah. Okay,
Okay,
yep.
there we go. Sorry about that. So this is what Open Room looks like. It's openroom.ca. It's really easy to find. It has their recent contributions is what they refer to them as. So you can actually go online, and these are orders from the Landlord Tenant Board that the landlord has uploaded themselves. So they have the discretion to they're public, so they can put them up here. So this is a really good tool.
So just put in, I'm just gonna pick a random name. So go into the search and just search the name Smith, just random name, and see what comes up. So here's all of the decisions that are out there with the name Smith on them. And if with the addresses, and you can also search by address, and I mean, Smith is one of those names where we could have 100 orders. But you're able to check and go, ah, that's the person who's trying to rent from me now, and geez, they've got, 5 orders against them. I don't think it's a good idea. So thanks for doing that. So Denise.
And then just quickly, just before we go, we're on this is Canley. Okay, and again, Canley is really easy to find. If you just Google CANLII, you'll come to this page. You can choose what kind of court or what area you want to look for. You can actually, there is a Landlord Tenant Board link. So, but you'll notice, and this is what I want to show these people, is that even the Canley recognizes that the board is not releasing orders to them as quickly as they should be, and they've actually put a notification up here that it's not that Canley isn't doing their job, it's that the board isn't referring those cases to them in a timely manner. So they've actually put up a disclaimer. So just be aware of that, and that's why both are good resources. Your client should be checking both if you're looking at potential tenants, because it is unbelievable what you can actually find in here.
Yep.
The professional tenants they're being caught out. Anyway, back to you.
Hey, thanks for doing that, Denise. So the point, I mean, Denise and I could do 2 hours alone on tenant screening, and then Harry could do another 2 by himself, I'm sure. But just a couple of tips. One of the things, it's a hot market, so we're getting competing bids for units, and one of the things that I'm seeing time and time again is fake credit reports. So tenants will show up with a credit report that says, they have stellar credit, and they are, they've been working in the same job for 15 years and blah, blah, blah. And then, you accept them on that credit report, and then sure enough, within 2 or 3 months, they're going into arrears. And you start doing some digging, and you find out that their credit report is false. So is it illegal? I have a friend who's a fraud squad detective, and I asked her that, and I said, is it illegal? I asked her, is it illegal to create a fake credit report? And the answer is no, it's considered art. But it is, of course, illegal to tender a fake, to try to pass it off as a real credit report. Having said that, as agents, you have a duty to do your due diligence, as Denise talked about. And part of that duty, if you're being paid to a commission for ensuring this tenancy, then you have a duty to actually pull the credit bureau yourself. You cannot simply rely on a credit bureau handed to you. And I can tell you story after story of false credit reports and the impact it's had, and we don't have time for me to do that. So if you don't have the ability to pull a credit report, then you shouldn't be doing rentals, frankly, but you should talk to your broker about ensuring that you get an account with the appropriate credit reporting agency. It's Equifax, TransUnion are the 2 that are the most reliable and most commonly used. So you can get an account. I mean, you have to go through a lot of steps, but if you're doing a lot of rentals, it's certainly something you should be doing. And I'm just looking at the time, so we only have a few minutes left. So I want to leave a couple of minutes for questions. So I'm just going to whip through a couple of things. And this is, if Harry could speak, he would do 20 minutes on this alone. Form 400s. People. The Form 400s are a requirement that you have to do with under TREB, which is, I know now, changing to something else. They are caca, and that is a legal term. There's all sorts of problems with them. But beyond that, and maybe they'll make amendments under the new act, but the point is that you're still required to do an Ontario standard lease agreement. You must do that. You can't just leave that Form 400 and say, that's it, I've completed my task, because you're doing a huge disservice to your client. And in particular, as Harry will tell you, if he could talk, there are so many clauses in that Form 400 that do not comply with the act. And that your clients may in fact be relying on, which could end up putting them into a whole heap and lot of hot water down the line. One of the things that's super important in the Ontario Standard Lease Agreement is the idea that service by email. So we often will get people checking off they accept service by email, but then there's no email address. So that's of no value, but you want that in there because to serve someone via email is way easier than any other type of service. It also has impact if you need to go after the tenant later on and your ability to serve them if you don't know where they reside. On top of that, the landlord must have an address for service. A lot of people don't want to give their personal addresses to their tenants. I get that. A lot of real estate brokerages will say, okay, use our address. I don't recommend that. It's now 5 years later. You no longer have any contact with your client, and all of a sudden there's litigation happening, and you've agreed to accept service on behalf of a client that you don't even know how to contact anymore. So it's the landlord's problem. It is not your problem as a real estate agent. You can be nice, but don't be stupid. Do not add liability onto yourself. And while we're talking about, I want to just tell you one last thing about another case that's important that you know, and then I think we'll probably have a couple minutes for questions. One of the other decisions that's come down of late is Ottawa Community Housing Corp. Daniel Crete and Ottawa Community Housing Corp. So this answers the question that we get on lease agreements that require tenants to do their own maintenance on snow shoveling and lawn care. So lots of lease agreements say that the tenant's responsible for that. And the act says that the landlord's responsible for that. And the act also says you can't contract outside of the act. So therein lies the problem. There's been many decisions over the last few years where the landlord's been penalized because they didn't do snow removal and they didn't do lawn care. So this case, which came out of, I think it's divisional court, Harry, correct me if I'm wrong. It basically speaks to this issue, and it essentially says that if you are renting a home where the tenant is a single family as opposed to a duplex, a triplex, or an apartment building, and the lease agreement says that the tenant is responsible for these items, then that is binding. So it's a very narrow scope, because often I'll see in a triplex that each tenant is responsible collectively for lawn maintenance, that sort of thing. Those are not binding, but if it's a single family dwelling, then it is binding. So I'm looking at the time, it's 10:56. I'm just gonna check the chat. And again, while I'm doing that, I mean, Denise and I and Harry can talk about this till the cows come home, but I wanted to just say one last shout out that if you appreciate the information that you're getting here from us, and appreciate the website, the Facebook page, and all of the communication that happens there. Please make that donation to for breast cancer and fighting breast cancer, not for breast cancer, and show your love that way. We would really appreciate it, and we want to hit that 25,000 mark. I'm just going to take a quick look at some of the questions. I've had a client claim that if the clauses from the Form 400 Schedule A are not attached to the standard lease form, they're basically void with no legal force. That's true. That's true. The real lease is the Ontario Standard Lease Agreement. That is the binding lease. And a question: can notices be given using email addresses if agreed for so standard lease, or it has to be in person? If the Ontario Standard Lease is checked off that you can give notices via email, then you can serve by email. And Kirk, unless that schedule is attached to the Ontario Standard Lease Agreement, it does not form part of the agreement. So it's not that hard to take it and staple it to it, add it to it. And I venture to say that a number of things in the Schedule A are probably not legal anyway, so those clauses would not work. And last question: if a triplex scenario and the tenants are willing to voluntarily help with snow removal, let's say, is there a way to put that in writing? Okay, so volunteering to do something is not binding. I volunteer to come to all your houses and cook you dinner. It's not a contract. So it's not enforceable. It's a volunteer. There's no consideration there. Anyway, we'll leave it there. Okay, so it is 10:58. I want to thank everybody for joining. I want to particularly thank Denise for her participation. I want to thank Harry and for his input, and again, wish him well. And we look forward to continuing working together to make it all happen and make it all wonderful. Thank you, Mark.
Thank you, Elaine. Elaine, just before everyone gets off, just everyone should be aware, we will be having our crystal ball session. We've had it every year with the same experts. Well, we'll see who's available for next week. But usually our experts are Dan Foch, Ron Butler, Jordan Skrinko. So we will see if we can get the team back together. It's already been out there, so we will have our crystal ball session. We're looking forward to everyone attending, and that will wrap up our sessions for the year. But thank you sincerely, Elaine. Thank you sincerely, Denise. Everything you do for us on a daily basis, running the forum and giving us the benefit of your knowledge, is something that we are so grateful for. So thank you for that.
My pleasure. Thank you. Bye, everyone.
Thanks all. Cheers.
Bye.